Hi, this is Attorney Mike Gravelin coming to you from Chicago as usual, and today we're going to look at another video with Sovereign Sits. This we're going to call Sovereign Sits in Court number 9. Let's do this.
Henry Eldon, I need whoever that may be to have a seat at the defendant's table. Right here's me, Eldon.
Oh, here it comes.
I'm a witness today of this.
Okay,
I'm a witness. Okay. Okay. What I'm saying is, he is present, and he's chosen not to step up there.
Oh, they got me early. I like how he refers to himself in the third person. I picture like a little leprechaun or something who's also in the room.
He's asking not for a appointed lawyer. He doesn't need an attorney.
I beg to differ here. I think an attorney would be a fantastic idea.
Okay, so I'm just a witness that he is present here, okay? And I will repeat that when the court reporter begins. Thank you.
So you're acting in the capacity?
I'm not acting. I'm a witness. This is an American national.
I don't know why judges put up with this thing right here where he said, he says he's a witness. There's only two people who can show up on behalf of somebody. The person themselves, they can represent themselves, or an attorney licensed to practice law in that jurisdiction. If you're not one of those two things, then you're not present in court. Plain as that. And don't forget to hit like and subscribe, or the dogs get it.
American national. Well, this is a court form. I need him to get in the defendant's seat now.
I'm just a witness. Thank you.
Okay. Henry T. Eldon. Henry T. Eldon. Henry T. Eldon. I have called him thrice. I have no response. Get up here in this seat right now.
The court reporter has to be established before anything can proceed.
I wouldn't put up with this either. He doesn't get to choose when he's going up there. He was called, and the judge ordered him to sit at the defense table, unless he's got some medical condition or something, which it's time to disclose. He should go up and sit there, and that's what he's supposed to do. Most of the court proceedings that I go to there is no court reporter. It might be required because this is criminal and it's been so long since I've done it. But I already wouldn't put up with this. He'd be looking at contempt for me right now.
Oh, okay. Well, get up in your seat now, and we will wait for that. We have some preliminary thing.
We're all waiting for the court reporter to be...
Do it now. Go. Unless you have mental hygiene papers. Mr. Eldon, I'm waiting. Not very patient.
You need to slow down. Slow down.
Have you established? All right, this is State versus Henry T. Eldon, Jr.
Hold on 1 second, sir. I'm sorry. Just give me a minute.
The birth certificate is ticket though.
Oh, this is very exciting. He brought his birth certificate. I wonder what will happen.
All right, this is State versus Henry T. Eldon, Jr. Mr. Eldon, I need to have a seat at the defendant's table, please.
For the record, I'm
Shut
a
up and
witness.
sit down.
This is Ted
Now,
Eldon.
you sit down and not say another word.
That's Ted Eldon.
Thank you. No. Would you get Mr. Eldon? Would you tell me where the seat is, please?
May I have permission?
You may have a seat right there.
Just to give a little perspective on this, I'll tell you a little story about my own career and the nearest I've ever come to contempt of court. So gather around the fire, everyone, and hear the law tales of Mike from many moons ago. But a long time ago, over 20 years ago, in Cook County, Illinois, a couple blocks over there at the Daly Center, I was before a judge. This is on a civil matter. And we argued our respective things. There was another attorney. Judge made a ruling. I disagreed with the ruling. I did not say anything to the judge, but I kind of rolled my eyes and gave him one of these as I turned around and walked out. That judge gave me a very stern, "Son, come here." And I went over there to the bench, and he said to me, quietly but sternly, "If you ever do that again, I'm holding you in contempt." And although I still think to this day he was wrong about the ruling, in terms of contempt, he was absolutely correct. And this is the concept this is the place I'm coming from when I see what these people get away with. Yes, pro se should get away with a little bit more, and I'm an officer of the court, I should know more, but I did not even say anything. It was a nonverbal gesture, and it was inappropriate. But this sort of activity, no attorney would get away with this. An attorney would be held in contempt every single time with this. He's getting lots of leeway.
You may have a seat right there. Place him in his seat, please.
Mr. Eldon, if you would please just sit here. I think it's going to make make the proceedings a lot easier. If you want to be heard in court today, you need to have a seat here, okay?
Anyone may call me Clem. Anyone may call me Clem.
Hi, Clem.
And I offer to the court a birth certificate of the name that they called. I'm also offering a reservation of rights long ago filed.
Well, thank you for that irrelevant paperwork and pointless gesture.
You'll be attended at the...
Do I have
Have a seat and we'll proceed. Sit.
Do I have standing to speak?
No, you don't. Sit.
I'm just waiting to pick up information.
Do you want me to tender that to the judge?
It's for the court reporter to review and then to give to the magistrate, I believe.
Okay.
What is your name?
I am Magistrate Harshbarger. Please have a seat. You've already been before me once. Have a seat.
Okay, well, he is the defendant. The case has been called, and if he's not going and he refuses to appear, then I think it's time to either hold him in contempt or issue a bench warrant for him and then arrest him on the way out. Either way, I'd go with contempt because he's right there. I just order him to be placed in cuffs right at that time.
Like that. Sit.
I'm trying to figure out how to regain the deposit money which was put to the court, $2,500. I'm trying to figure out how to do that.
Well, we have to have a hearing first. You have to comply with all these vows you have in front of you. You need to have a seat now. You are going to be held in contempt. There are 3 criminal contempts. You wish to place more money with the court, be my guest. Okay? Have a seat and we'll proceed. This is a pre-trial hearing. Okay? You may make up your mind what you wish to do. We have an attorney here for you that you may discuss things with you feel you need to. Okay? And he's about ready to give you some instructions about court behavior. Okay? Have a seat.
I've asked.
Have a seat. You are disrupting the court. 1. Have a seat. You are disrupting the court.
and then he's going to. Why does he have to stay?
May I say?
Because it just, everybody gets an opportunity. He's going to get a chance, and you're going to get a chance. Everybody gets a chance.
Why does he have to sit? Can't he stand?
To identify the parties. We're identifying parties.
Oh.
And when you talk to the
That's the
judge,
defendant's seat?
yes, sir. This is the defendant's seat.
Thank you.
Okay.
He's not defending anything. You see by special appeal.
So close. So,
Have a seat, please.
I would like to speak to the court, and I have information to present.
This is disrupting a governmental process.
I have no idea what's going on here. I have never seen charges.
Want to place an arrest or something?
I want him to place for disrupting the court.
All right, Mr. Allen, can you stand up when the police come around and place your hands behind your back, if you would?
And who are you?
I'm Deputy Sheriff.
M.A. Dolan.
Yes, sir.
And have you a badge number?
I'm 97.
And do you have a warrant, a signed
I do
warrant?
not have a warrant. I'm just going.
No, I don't have a warrant. I've got an order from a judge that you heard and we all observed right here, and you have on video.
Made aware by the judge that he wants me to take you into custody for obstructing the judicial process, okay? So,
I don't know how I'm instructing.
Last warning.
you won't comply
Get in your
with what he's
seat
asking
and
you
we'll
to do.
proceed.
Okay?
There seems to be meaning to what he's doing. I'm
Okay.
here as a witness to what's going on.
I realize that Mr. Eldon doesn't want a lawyer, but I would ask, in an effort to move this process forward, since it is a mere pretrial and generally less formal than an actual hearing like a trial, that Mr. Eldon be allowed to present his information from the seat back here as opposed to sitting at
So
the table.
disrupt the entire.
Well, I mean,
Why
Judge,
isn't
I
he
would
in
ask,
court?
that he be allowed to sit back there, but only speak when the court addresses him, as opposed to this apparent free-for-all that we've entertained. But that he would just be permitted to speak when addressed, but to be allowed to remain in that seat as opposed to that counsel table.
A free throw?
Up until now, it's been, yes.
And from which end is the free throw?
Oh, I understand that, and I'm not going to argue about that, Judge.
That was interesting. I think she's the public defender, and she steps in to sort of calm the situation. The judge is, goes along with that for whatever reason. Overall, like I said, I think he does a good job. I would say I don't care. He needs to get up there, or he's going into custody right now. But easy for me to say from here. And it doesn't really matter in the end. Of course, it doesn't help this sovereign citizen. All his antics don't add up to anything.
But I would ask that in order to move the process forward, that he be permitted to remain where he is, and that he will speak and get his opportunity to speak from where he is, as opposed to from the defense table.
It's going to be up straight in front. Okay. Mr. Eldon, stand by. You have been charged with 13M 8570 refusal to print. You have been charged with 13M 8119. Okay, 20, 21, 22, 23, and 24. 6 counts of fraudulent service of indebtedness. You have been charged with, again, 79, 66, 67, 68, and 65 fraudulent official proceedings. And you've been charged with 13M 8561 through 66, fraudulent service of indebtedness. Okay, for a total of how many counts? 12 to 13 counts. How do you plead?
Do I have standing to speak?
How do you plead? Guilty or not guilty?
I'm here by special appearance.
Guilty
There
or
are
not
issues to
guilty?
resolve, which have not been discussed yet. I would like to
A plea?
see your oath of office. I'd like to see your letter accepting and acknowledging your office.
I really like how the judge just refuses to acknowledge this nonsense. On this level, I think he does a really good job. He just lets him go, but just refuses to respond in any way whatsoever, and that's exactly what it deserves.
And I would like to see the same for the prosecuting attorney, and to know the names of everyone in this room. I need that before I understand what's going on, sir.
I think even with all that information, you're not going to understand what's going on.
Have you offered him a plea?
I have not offered him a plea yet. I'll offer Mr. Eldon a plea guilty to 1 count of fraudulent service of indebtedness, and the state will stand silent at the sentencing.
Sir, there are many things we haven't gotten to before we get into the things that you wish to discuss. I need to see your oath of office, your letter of acceptance.
So, are you entering a plea today to the 1 count of fraudulent official proceedings?
I don't recognize you or understand your authority until I see the things that I'm asking for.
All right. So the answer, and I will answer for him, is not guilty. Okay?
I haven't made any plea, nor should you make any plea.
All right. He will not
We
answer.
can't be to that place, sir, until we establish.
If you would get us a hearing date, I will give him the hearing date, and we shall proceed on to a bench trial.
So you yourself are not going to validate anything about your own office. Your authority, your position, your acknowledgement letter, your oath of office, you're not going to do any of that. So how do I know you who you say you are? I don't know that. I don't know who any of these people are.
All right. Forge people here, you all can get it. February 19th at 10 a.m.
I don't accept that.
Okay.
I don't accept anything that's
whether
happened
you
here
accept
today.
it or not.
I did not, do not, and
You
will
have
not
been
consent
told,
to any of
and
these
it has been
proceedings.
recorded. Again, what is the date?
February 19th, 2014 at 10 a.m. He's not in your jurisdiction is what he's trying to say.
Okay. Well, he is. Today is
he
your
is
day.
not.
You're doing it by presumption, and you are electing not to validate your own position.
Fork him out.
Court adjourned. You all would exit the courtroom, please. Please report.
February 19th.
Well, there you have it. Admittedly, the video would have been better if he would have gotten cuffed, tased, or had his window smashed, but no such luck. At the end of the day, with some minor issues, I think the judge handled it well. It gets set over for trial. He'll be convicted because he's doesn't make any sense. He doesn't know how to defend himself, and I'm sure he did the underlying act. Well, I'm not sure. I'm guessing he did the underlying act because he was doing a variant of it right there on his own video. That's another thing that absolutely amazes me about this. Most of these videos are taken by the sovereign citizen. They make complete fools of themselves, and then they actually release it. I don't think that's in the state's custody. He got done, reviewed that, and thought, hey, I did a great job. It's amazing. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.